What authority is the president invoking right now to justify federalizing and then sending in the Oregon National Guard?
So it would be Title 10, Section 12406. So Title 10 is the United States Code that deals entirely with the military, and Section 12406 is the nationalization of the state National Guard part.
And what does that code say that's relevant here?
So basically, there are three circumstances in which that section would allow the president to nationalize state troops, and those would be if there's an invasion by a foreign state, an insurrection, or if federal law is effectively unable to be enforced. It doesn't really look like there's any serious claim that there's a foreign invasion. I know the president has claimed that drug dealers from Venezuela are an invasion, but even if that were true, which I think courts have rejected or will reject, but even if we're true, that's not here. That's in Florida. Insurrection, we're looking, doesn't have to be quite like the Civil War, but we're looking for that sort of complete uprising. And again, a protest outside the ICE building, even if it gets violent, even if you could show that, I don't think that quite rises to an insurrection. So the last basis would be the inability to enforce federal law. And we don't really see that here. ICE is able to go out and do what it's doing to detain people that it wants to send into removal proceedings. But if the president could articulate facts to suggest that, hey, ICE actually is being obstructed from carrying out its mission, then maybe that might qualify under that third provision.
Is that something, has the administration provided evidence to support its invocation of this, based on that third provision? Evidence to say, here's what's happened, here's the ways in which Portland police have failed to intervene in ways that in the end have meant that we cannot enforce federal law. Have they provided evidence for that?
I think that it sounds like the president was relying on some videos, but the videos may have been from 2020 when there were actually attacks on the federal courthouse and so on. But in terms of evidence versus allegations, I think it's more claims that we're seeing. The president claims that Portland is war-ravaged, which I assume is an exaggeration, but is intended to give the idea that it's lawless. The president has claimed that the ICE building is under attack every night. And really what this whole matter will hinge on in the end when it gets into litigation, when the lawsuit's been filed, but when that is processed, will be the actual evidence presented in the litigation. So not claims, but how often is the ICE building attacked? When we say attacked, what do we mean? Do we mean Molotov cocktails are being thrown against it? Do we mean just graffiti? Do we mean that there are protests and loud noise? At some point, the judge assigned to the case will have to determine, okay, if we're operating under 12406, does this actually satisfy the inability to enforce federal law, or is this, either just legitimate protesting or maybe legitimate protesting plus some degree of street violence, but not of the sort that obstructs federal law?
I want to hear more about your thoughts about the Oregon lawsuit, but we do have a California one based on the administration's earlier decision to send thousands of troops, not 200, but something like 4,000 into Los Angeles. What did a federal judge there rule at the beginning of this month?
So this is already complicated, but we have at the trial level what we call a district judge ruled that the president could not do this, that it exceeded his authority based on the actual facts on the ground. And that judge issued what we call preliminary injunction. So preliminary injunction basically pauses whatever it is that the party that it's ordered against wanted to do. It's not a permanent remedy. The idea of it is that we know litigation takes a long time to finish. And so while the litigation is going on, we might want to keep the status quo if the judge feels that what we call the balance of the equities, that on the one hand, how likely is the party suing to win? And on the other hand, what is the likelihood of irreparable harm if we don't enjoin the behavior?
If we don't stop the behavior.
If we don't stop the behavior, yes. As a side note, a good example of why we have these preliminary injunctions would be the birthright citizenship order that's under litigation as well. Now, if that order took effect and it takes 2 years to resolve, even if at the end of 2 years a court ultimately says, yeah, you can't do this.
You mean you cannot revoke citizenship of people who were born here?
Deny it to people.
Deny it.
Yes. But if you didn't pause that order, that would mean that during the litigation, hypothetically 2 years, there would be a whole bunch of people who are born here who would not be citizens of the United States, and they might not be citizens of anywhere, depending on, how far you trace back the ancestral lineage.
In other words, the harm there was seen as serious enough by judges that they said, even though this has not gone through all of the legal channels, we're not going to let it go through now because, first of all, there's a good chance we don't think it's going to survive a legal challenge anyway. And if we just say, well, let's let it go in the meantime, many people will be seriously harmed.
Yes.
So is there a connection between that reasoning and the L.A. or now Portland cases?
It is. There is. Although I think what's a little more challenging is that in the L.A. case, the Ninth Circuit Court of Appeals, which is the Court of Appeals level above the trial levels, dissolved the preliminary injunction. So that means that what the trial level judge had said, oh, hold on, you can't do this. The Ninth Circuit said, well, we'll get to that, but right now we're not saying the president can't do it.
Meaning, among other things, that means that California case based on Los Angeles does not have an exact bearing on the Portland case?
Well, it does not have exact bearing in the sense that that's about whatever's happening in LA, and you have to look at the facts on the ground in LA. And so even if, let's say we fast forward and there's a resolution of that case, and the resolution is either the president can or cannot do what he wants to do in LA, that has binding effect on the president and LA or California, but it doesn't have what we would call binding effect on anywhere else because Portland and Oregon are not a party to the case, and only parties to the case are actually bound by the order. So this means if either side violates they do what they're not allowed to do by the court ruling, they're actually in contempt of court. You could bring proceedings that way. What happens in LA could have bearing here, though, in the sense of what we call persuasive authority. So again, if the trial judge is ruling in LA, the judge here in Oregon might look at that and say, I know we're not bound by that. I'm not bound by what another equivalent judge has decided, but I think that this looks basically the same. We have claims of riots and attacks in federal buildings, but I don't see the evidence there, and they didn't see the evidence in LA. And the ultimate conclusion the trial judge had was that you can't do this. I'm persuaded by that.
Can you remind us how this authority, how nationalizing federal troops, sometimes against the wishes of governors, has been used in the past?
Yeah, so there's a different whole sort of statutory provision under the Insurrection Act, which essentially can be used maybe if the state is obstructing the federal government. And so I think the best example of that was after Brown versus Board of Education ordered desegregation of schools. We know some southern governors refused and actually used state troops to block black children from going to the schools that they now are entitled to go to. And President Johnson, in at least one instance, did order federal troops to go escort the school children into school. So that's an example where we have the state fighting with the federal government and obstructing what would be the federal law, in this case, the Equal Protection Clause. And so, I think that we understand, okay, maybe we do need troops because when it comes down to it, if the state is resisting, then you need to have the bigger army there to enforce federal law.
Wouldn't the Trump administration say that sanctuary states are resisting federal law by not taking part in immigration enforcement, not saying, here, we picked somebody up for this crime and we know you want them, so here they are?
Well, there's a difference between not lifting a finger to help versus getting in the way. So there's no duty for the states to cooperate. And so if typically what might happen is somebody is convicted of a crime, they serve their sentence, they're due to be released, and ICE wants to then pick them up to begin removal proceedings. So ICE would say, they would lodge a detainer notice. When this person's going to be released, let us know so we can pick them up. The state can comply, or it can say, yeah, we're not going to do that. And that would be Oregon's policy, is not to cooperate with ICE. But that's different from if ICE is waiting to pick up the person and the Oregon officials say, hey, you know what, let's take you out the back way. We're going to call you an Uber or a Lyft so you won't have to be caught by the ICE people. That starts to look a little more like obstruction, because now Oregon officials hypothetically would be taking an affirmative step to thwart federal enforcement.
Not hypothetically. I mean, that is not in Oregon, but that led to federal charges for a judge earlier this year.
Yes. But simply saying, you know what, you do your thing, we're doing our thing, but we're not taking part at all in helping you, that's not obstructing.
So we've been focusing so far, if I understand the legal issues correctly, on whether or not the president can lawfully federalize the National Guard and for a particular situation and send troops in. To me, that's different than whether or not, once those troops are there, if what they are doing is legal, if the particular actions, if, say, for example, because I thought that the California judge said that that his ruling was also saying that they were doing things that they shouldn't have done. They were doing law enforcement, and that's not legal. So are these two separate issues, both whether or not they should be there in the first place, and if they are there, are they doing things that they are authorized to do?
No, that's right. I mean, they're related, of course, because they both stem from federal law, what is authorized and what is forbidden. But they are two issues, and so I think you've summarized it correctly. So the first issue, again, is does the president have the authority to do what the president is doing? And that's what we previously discussed under 12406. Now, if we just assume that the president is able to nationalize the troops, then the next question is, okay, well, what are the limitations on what the president can do with those troops? And that's where we need to bring up the Posse Comitatus Act. It's a post-Civil War law that essentially says you cannot use the military domestically for law enforcement purposes. So what do we mean by law enforcement purposes, and what would not be law enforcement purposes? Well, if the whole idea is that this is defending federal property from attacks, so again, we might hypothesize a certain set of facts that would allow the president to call out the troops. Maybe the protesters are attacking ICE officers as they're coming into the building or exiting the building. They're again, throwing Molotov cocktails and so on. The troops might therefore be allowed to protect the federal building. So protection of the building is not law enforcement; it's defending federal property. But if ICE agents say, "Hey, we're going to go raid this warehouse and we look for undocumented immigrants. We could use your backup. Come with us." Now the troops would be helping engage in what would be essentially law enforcement. In this case, ICE is technically not law enforcement in terms of policing, but obviously it's still carrying out civilian law. Or if FBI agents say, "Hey, we have a lead on somebody who's helping smuggle people in to evade immigration laws, come with us to raid their home to help us search." Again, doing a search, even pursuant to a search warrant, is law enforcement.
Even if in the end it is federal law enforcement who is actually doing the arrest, a judge would say, no, but this is illegal because part of the support was the military, were members of the National Guard.
Right.
We were in Eastern Oregon yesterday working on a future show, and at one point we talked to some folks in Hines. This is outside of Burns in Harney County, to get their take on this news. I met a man named Chris Larson there. He lived in Portland, he said, for a number of decades, and he moved to Hines because the city had become, in his words, pig slop. I want to play you part of what he told me.
I'd just like to see the homeless and everything got off of there, and people stop harassing law enforcement, let law enforcement do their job, enforce the laws we have, and move forward. I have people in law enforcement that I know, and they just can't get the directive from upstairs to do their job, and they're frustrated also. So if the feds got to come and do it, so be it.
Can federal officers or federal troops do anything about homelessness in Portland?
No. So again, I mean, to boil this down very simply, we have a federalist system, meaning we have state and federal government. Each has its own domains. The federal government federal law enforcement can only do what they're authorized to do by the Constitution and federal law. And so regular policing is a strictly state matter. So unless you could point to some federal law that gives the FBI or whoever the authority to police the streets, it's not within their jurisdiction.
The timing right now is interesting. A spokesperson for the Oregon National Guard has said that the earliest troops could actually be in Portland is Thursday, but he's not betting on that. It might not be until next week. There has to be a vetting process, a volunteer process. We just don't know when they're going to be there. On Friday, that's when the first hearing is scheduled in federal district court. What do you see as the possible timing here for a ruling that could actually have a real bearing on this matter?
Well, I think the first thing would be to get a temporary restraining order, which is similar to the preliminary injunction we discussed earlier, except that it's quick and dirty. The idea of the TRO is we need to allow the parties time to prep for the preliminary hearing, but in the meantime, maybe we need to keep the status quo again for similar reasons. So
could that come on Friday?
I would expect that that's the first thing that the state has asked for, and so that would only be very short term, maybe a week, 10 days, something like that, so that during that intervening time is when the parties would be getting ready to litigate the preliminary hearing motion, which would be more of a preview of what we think the judge is likely to rule, but again, not a final ruling, but would take into account the likelihood of success on the merits.
Finally, about a week ago, the president designated Antifa as a domestic terror organization. What are the legal implications of that? And is that connected to this federalization of the Oregon National Guard?
It's not clear to me what that really means. It is a defined term in the federal statutes, the terrorism statutes, but there's no consequence to it, whereas there is for being designated a foreign terrorist organization. Al-Qaeda, for example, is on the State Department's list. So it is a crime to provide any material support to a designated foreign terrorist organization. Doesn't matter if you actually have good motives. If you give money to one of these organizations because they also give medicine or food, but they also are listed, you've still committed the crime because money's fungible, and if you give them money for good purposes, they
could turn into a bomb.
Yes,
but that's not the case for a domestic terror organization under federal statute.
Right. So I suppose this is a bit more of rhetoric. And maybe if, again, we hypothesize a certain set of facts that maybe don't seem to exist, but could possibly, if there were some evidence that you had Antifa as, let's say, a coherent organization as opposed to sort of a collective in different cities and so on, but or at least here in Portland, you have a coherent Antifa, and they are plotting attacks against the ICE building. It doesn't really matter if you call them a domestic terrorist organization at that point. If you actually have evidence that that's what's going on, again, I'm speaking purely hypothetically here, then again, you could act on that. You could prosecute for conspiracy to engage in terrorism. You could, and maybe, again, that might be a call for the troops to defend the targets of this sort of hypothetical terrorism. But again, simply calling them domestic terrorist organization, I don't think it really achieves anything.
Tung Yin, thanks very much.
Thank you.
Tung Yin is a professor at Lewis and Clark Law School.
Just zooming way out, why do we treat the military and the police differently from a legal perspective?
Historically, the Posse Comitatus Act, it's post-Civil War. It's actually a little bit of a sketchy history to it because during the whole Reconstruction fight, the southern states were occupied by military governors and sort of forced to submit to federal authority to ratify the 14th Amendment to be allowed to rejoin the Union. The sort of backlash to that was that they sort of chafed under this military rule, and especially did not want to have too much federal law imposed upon them. So the Posse Comitatus Act was kind of a compromise to say, but for the Union states to say, okay, we won't use troops to enforce federal law, so that you don't have this force multiplier in that sense. So that's sort of the historical rationale for how it came about. But I think you might ask today, like, why do we still have it around? And part of the idea, I think, is that the military's use essentially is for armed conflict and war fighting. And so we understand that if we actually did get invaded again, like, say, Pearl Harbor, that we want the military to be fighting off the enemy. Of course, the local police would, have some role in it, probably just by the nature of where they are. But fighting in a war setting is what the military is good at. But law enforcement is different. We need officers who are trained in Miranda rights. We need officers who are trained in search and seizure law. And the military is not trained for that because they have too many other things to be trained for. So having people who aren't necessarily trained for what you need leads to not very good results.
So this is going to the courts now. What if the president just ignores the courts?
This has been talked about among law professors since February or maybe even earlier. We don't know. Historically, we can look back to when President Nixon was facing impeachment and the issue about the missing tapes or the tape recordings came up. And he claimed executive privilege not to have to turn them over. It went all the way up to the Supreme Court. And there was some thought about what if the president ignores the Supreme Court. And the Supreme Court, I think, was cognizant of this because they made sure it was a 9-0 vote in favor or against the president. And President Nixon did comply with the order, turned over the tapes, and we know what happened after that. President Andrew Jackson was once famous for saying in advance of or was it, maybe it was after Supreme Court ruling, well, Justice Marshall has made his ruling, let's see him enforce it now. Because when it comes down to it, the Supreme Court has no military force or even sort of law enforcement force to carry out its orders. It has to depend on the willingness of Congress or the president or anyone else to comply with its rulings. So I think we don't know. You could argue that in some of those earlier cases involving the forcible removal of people in the country who probably should not have been removed, and where there were court rulings saying, hey, don't remove them, that those were violated. And maybe the backdrop to this or backstop to this is that, well, it wasn't the Supreme Court who ordered that, and at least President Trump is making some signals that he respects the Supreme Court. But we see that the Supreme Court also is kind of being a little bit careful. They've been making some rulings that don't directly forbid the president from doing things, but kind of suggest, maybe you shouldn't do this. I think maybe that's an indication that they're saving their powder. They're waiting until, okay, we need to make sure that when we rule against the president that we're unified and it's going to be an airtight case and where the public opinion is really going to support the ruling. Maybe that's what they're waiting for.